And today, for the balance of our conversation, we're really going to talk about how the profession is starting to put shape around guidance for how lawyers should use generative AI. And the American Bar Association issued its first formal opinion on generative AI. And we're also going to talk about some state bar associations' approaches to this. But maybe to level set, Bridget, I know this is a lawyerly audience and many people sort of understand all the different regulatory schemes, but could you talk a little bit about what these opinions really mean, how binding they are, and why we're sort of focused on them this episode?
Yeah, I wanted to touch on this briefly before we dig into a couple of specific examples, because of course, regulation and sources of law come in many forms. Some states are looking at legislation around this technology, or at least California is. I guess I don't know for sure if any other states are as far along as California. California sent legislation to the governor's office, I believe. I don't think he has signed it yet. And the White House, of course, issued some guidance last spring, I believe. And Congress could issue its own statute about how generative AI should be regulated. And then courts eventually will issue substantive opinions when there are legal challenges around the use of technology. In the meantime, bar associations, state bar associations, and the ABA have the opportunity to issue these opinions on the ethical use and potential risks associated with the technology. And a number of states have done it, and they all seem to be converging on identifying the same kind of areas where lawyers should be looking out for it. Now, none of these ethics opinions are binding precedent in any way. They're not, if a lawyer doesn't follow the advice of her state bar opinions recommendation on how you should be approaching, for example, billing with respect to this technology, that doesn't mean you all of a sudden have a winning lawsuit against that lawyer if you're that lawyer's client. But they are often relied on by courts and regulators as authoritative sources of the norms and the best practices in the profession. And so they're pretty useful for any lawyer who's thinking about how to incorporate the technology into her practice, to at least be familiar with what the state bar's statements on the use of the technology and how it interacts with the state rules of professional conduct, as well as the ABA's opinion, which it issued, well, I think it was last spring, you'll remember exactly, but it was ABA's formal opinion, 512, on the use of generative AI in legal practice. And why don't we start by talking a little bit about 512, just because the ABA is pretty authoritative, at least across the practice and across the states. And so it makes sense to understand where they came down on the various issues that state bars are dealing with. So what's your sense of the ABA opinion 512, and what do you think it does well? Are there any questions it leaves open? What are your thoughts about it generally?
Yeah, so the formal opinion 512 came out earlier this year, and it's pretty comprehensive in its approach to thinking about generative AI with respect to the rules that sort of govern lawyers, or the norms, and what we should be doing. It's a 15-page opinion, and it covers everything from competence, underscoring that lawyers should understand the capabilities and limitations of any AI tools that they use, Gen AI tools that they use. I think notably it says that lawyers do not need to become experts in the underlying technology, but they should generally be familiar with the technology itself and what it can and cannot do. It talks, of course, about confidentiality. I think this is the biggest question that comes up, or concern that comes up for law firms in particular, about safeguarding their client information. So being sure that you understand whether you're using a public model into which you should put no confidential or sensitive information. There will be some really interesting nuanced questions, ethical questions, I think, in the years ahead about sort of like hypothetical questions that you ask publicly available models with the purpose of, using the feedback for your client facing work and things like that. But for now, just be careful of what you put into the system. There's information about client communication. So how should we be talking with clients about the use of generative AI? How aware should they be? And in what cases should we be disclosing the use of generative AI to clients? A repeat of our obligation to have candor before tribunals. So this is likely inspired by the ChatGPT lawyer and other cases we've seen about hallucination of case names. So making sure that lawyers don't uncritically rely on Gen AI generated content and are double checking everything that comes out of it to make sure that you are citing accurate case law and statutory information. Supervision, lawyers remain responsible for the work produced by generative AI. And then there's some interesting discussion about fee arrangements. So, what the considerations should be when you're billing clients in a world where something that used to take you several hours might take you under an hour now, or a world where you want to invest in generative AI technology. And right now, it's very cost prohibitive for many firms. So, what are the rules and considerations around charging, passing on the costs of those investments to clients? So I think overall the ABA did a nice job here of reinforcing the existing obligations that lawyers have to their clients, making it clear. And I think they're being realistic about the idea that this technology is here and it will change many things, and getting out early and ahead of it to provide some guidance, but also making it clear that we're not changing our relationship between lawyers and clients overnight. As a result, we still have all the existing obligations, and they're not very different in this world than they were before. It's just a new tool. Most of the conversation I've seen around the opinion has focused on the idea of client communication. So they talk a little bit about how you would need to be transparent if you're using Gen AI for something that is more strategic or substantive, that was at the heart of why they engaged you in the first place. So the idea is sort of like if you are delegating in some sense the decision making or strategy to Gen AI, your clients should know. And then the fee arrangement provisions has really garnered a lot of the attention in the private sector, particularly because midsize and small firms are feeling a little bit outmatched at the moment around being able to invest in this technology as compared with global firms. And also because there's huge concern, as I think there should be, on the business model front about what all of this means for the way that lawyers charge for their services. But overall, I thought it did a really nice job and left open some important questions for conversation. What did you think, Bridget?
Yeah, I agree with all of that. I remember the early days of the technology. We saw some very quick reactions from some courts, especially courts that had experienced lawyers using the technology and not checking its work and citing fake case names in a number of cases. That one guy in New York who set us all back like 4 years. But I think that this ABA opinion and many of the state bar opinions, we'll talk about a couple of them in a minute, are a careful, thoughtful reminder that just because there is a new way of doing your legal work, your ethical obligations haven't changed. You know, you might have to make sure you understand enough about the technology to be able to carry out those duties that you swore an oath to carry out. But the duties don't change. It's funny. Lawyers often have a very quick initial reaction of risk aversion with things that are new, and lots of technology can be new for lots of lawyers. I used to give a lot of talks when I was on the bench about judges' use of social media, and I I had many judges who would say like, "Oh, I would just never do it." I mean, you and anything you do could go viral. And I sort of thought like, well, yeah, what are you doing? Like, what is it that you're doing that you're worried about going viral? Because the thing is, like the ethical rules of conduct for judges are the same if you're just in a room with four people having lunch as they are if you're on, a live spaces event on some social media platform? How about just, play by the rules no matter where you're playing? And I think it's similar with lawyers and technology. The rules of the game are not different. The ethical ways in which you interact with your clients, your adversaries, the tribunals you appear before, and the public are no different than they were before the technology. Just understand enough about the technology to make sure you can carry them out. And I think that's how I would summarize the ABA opinion, which does a nice job of making sure that the places where you might need to understand a little more about the technology are called out for lawyers. And I think if you read through it carefully, you'll be in really good shape in thinking about what this looks like for your firm. And the state ethics opinions, in my view, are similarly comprehensive. For the most part, thoughtful and careful. I've been impressed with a number of them that have, and I think the ABA opinion does this as well, have noted that because the technology is changing so quickly, that this ethics opinion itself should probably be revisited pretty regularly in case there are new aspects of the technology that folks need to know about to make sure they can continue to carry out their ethical practice while using it.